Okay, good evening and welcome to this evening's webinar on superannuation and estate planning. So tonight I'm going over obviously superannuation, but how it fits in with estate planning. So most of us have superannuation these days. It is compulsory for employers to pay into it. Quite a few self-employed people don't pay themselves enough super, unfortunately. But super is also a very highly regulated asset and it's different from everything else. So it does have to have special attention. And look, for many people, it's one of their biggest assets as well, particularly people even all the way up to 40 years old. Because the life insurance component can be quite large on super. And then depending on how much people put away into super during their working career, obviously it can be of quite a large asset coming into retirement and then drawing a pension. So it's quite important that it not get overlooked. And unfortunately, a lot of people do overlook it. So, look, what I'm going to do tonight is just briefly introduce myself a little bit better and then give you an overview of what estate planning is and what it should include. Then I'm going to talk about the types of super funds that there are because they are all treated slightly differently. Then I'm going to talk about how superannuation is dealt with in respect to estate planning, particularly with binding nominations and why they're important. And then I'm also going to talk to you about who can even get your super if you pass away. And then towards the end, I'll explain the estate planning process and where dealing with super fits in. So we should only go for about half an hour to 45 minutes. I'll take questions at the end. So you can type those into the chat as we go. And I will jump backwards and forwards, like I said, so I can check out what you're chatting about and answer them a couple of points along the way. But otherwise, I'll get to them at the end. Yay, there I am, if you didn't see me when you first came in. So, my name is Jacqui Brauman. I own TBA Law. It's the 13th year that I've been a solicitor. I've been working for myself for about 6.5 years. As well as the law degree, I went on to do extra study and I did my master's degree specifically in wills and estate planning. And then after the master's degree, I also went on and did another 12 months accreditation process with the Law Institute of Victoria to get the specialist accreditation. So I get that lovely little logo that's down there in the bottom corner. If you're looking for specialists in any area of the law, that's the logo that we get. There's about 85 of wills and estate specialists in Victoria, and I think there's between 12,000 and 20,000 lawyers, so not many specialists in this area really. I am the only one in central Victoria, and there's another lady in northeast Victoria, and there is a man up towards Echuca, and I think there's someone over in Bendigo. I think that's about it up this way. I'm also a wife, a daughter, obviously. I'm a sister. I have a sister. I'm a runner. I'm a fishing person. So you can see down in the other corner there. my husband and my dog on our boat over in Eildon. So that was last spring or so. So yeah, that's my world. So, estate planning in the current day and age. Very different than what it may have been 50 years ago, for certain. Even 20 years ago, it would have been very different. So, certainly 50 years ago, estate planning probably just would have been a will, and that's about it. And 50 years ago, people approaching retirement would not have been expected to live for very long, and they certainly wouldn't have had the sort of average assets that people have these days. So quite a few elements have changed. People own a hell of a lot more property. Tax laws have obviously changed and become a hell of a lot more complex. Superannuation has been added into the mix. So it was very rare to have someone with superannuation 50 years ago. And 20 years ago, it would have mainly been people in the public service, because you could still, although I think they still had the compulsory scheme, you could still access it and take it out. The other things that have changed have been that people are obviously living a lot longer, so that changes the sort of illnesses people get later in life, increasing cases of dementia, so people losing capacity, hence people needing powers of attorney more often. Also increasing issues around medical care, people not being able to stay at home, the increasing concern that the medical industry has over litigation, and hence they're so careful about who they take instructions from. Therefore, we're moving more and more into doing advanced healthcare directives. Also, 50 years ago, it would have been fairly rare to have someone with a family trust, but these days family trusts are quite common. And look, aged care is another industry in itself, which has, even changed over the last 5 to 10 years, and will probably change again under the Royal Commission, particularly in terms of how it's funded, how people are assessed, and what they have to pay to get care. So all these factors have to be taken into account with estate planning now, which they wouldn't have had to have been years ago. And look, family dynamics has also changed as well. There is more blended families. There also seems to be more angst more often, I think, between families, estrangements. Certainly, whether vulnerable beneficiaries have increased or not is questionable, but it's certainly more obvious these days. So, drug and alcohol problems, gambling problems, or even people with mental illnesses. It's certainly more likely these days that parents will want to make sure that inheritance is not wasted by a beneficiary like that. And look, the laws around claims against estates is also something. So it's quite a strategic process. And super is a big aspect of that. So, sorry, I'm just moving to the next slide. I'm just going to actually jump back for a sec. Check in and see how we're going. All right. Okay, sorry. Nothing in the chat just yet. It took a little while there to switch. Share again, sorry, there we go. All right, so types of super. So I basically categorize super into three main types of funds. It's the easiest way for me to explain it. So we have the industry funds. So those are the ones that are really, they were getting a lot of advertising for a while there. They're the ones where the people make the little symbol with their two hands. There's quite a few funds that are classified as industry funds. They tend to be the ones that obviously industry supports, and employers generally need to choose a fund that they would like their employees to sign up to. When they start a job, employees don't have to sign up to the chosen fund. They can nominate their own fund, but particularly a lot of particularly young people who aren't focused on their super, they'll just go, yep, we'll go with the one the employer likes. And so they end up with multiple funds from other places and they don't roll them in. So this is part of what the Productivity Commission has recently come out with a report about, to try and tidy that up, but also potentially to minimise the number of both industry funds and retail funds. So retail funds are another class as well. They're also run by large organisations, just like an industry fund. So you're thinking about more like your AMPs and your IOOFs and places like that will run retail funds. So you can also join up to these directly and also tell your employer to pay into those. There are retail funds that are available to financial planners only and not to the public direct. So there are a whole set of funds there that, may have different insurance and different fees and different components. But both those two types of funds are heavily regulated by the law, as well as their own trust deeds, which are quite lengthy. And the corporate trustee of that super fund obviously allows multiple hundreds and even thousands and thousands of members into those super funds. And so your third class is your self-managed fund. Now, these have become a lot more popular. I don't really want to weigh into whether they're good or bad. There's obviously good and bad about them. So a self-managed fund is where you look after your own super, basically. So you get your own super trust deed. You appoint yourself as the trustee, or you create your own company and appoint the company as the trustee. You can have only 4 members of a fund, so it's usually only husband and wife. Sometimes a couple of kids are tacked in there, or one kid and their spouse. And it's regulated differently and regulated by its own trust deed as well. So Productivity Commission, and also watch what the proposals are around self-managed funds. A lot of the new tax laws that are being proposed by the Labor government coming up to the election will affect investments into self-managed funds, and the ability to borrow money to buy property in self-managed funds. So it might also be a changing industry, particularly because a lot of self-managed funds potentially are underperforming. So the Productivity Commission has suggested that underperforming funds have to be brought up to standard, and if they can't, that they won't be compliant, and so the super will have to go elsewhere. So it'll be interesting to watch that unfold over the coming years. But having said all that, something that the legal industries have been lobbying for a long time has been the huge gap or even oversight about what happens to super if someone passes away. If the person hasn't taken their super out as a lump sum during their life, and the super is still in a super fund, any of these three types of funds, when they pass away, it's not an estate asset, essentially. So your will does not cover what you want done with your super. In fact, the trust deed of your super fund generally dictates what happens. And so particularly with industry and retail funds, that puts you at the mercy of a huge retail or corporate trustee with a trust deed who doesn't know you or care much about you, regulating what happens with your money. Now, your money won't disappear. It still has to be paid out. But to whom, in what percentage, is the big issue. The issue with self-managed funds is the control of that self-managed fund. So just like with an industry and a retail fund, you have a major company who makes those decisions. With the self-managed fund, while you're alive, you have control, which is all good and well. But if you no longer have control, either because you've lost capacity or because you've passed away, then who ends up in control of it and makes sure that you what you want to happen to your super actually happens? So these are the things as estate planners that I'm thinking about. I'm not thinking about how you've got your money invested or where. All I'm thinking about is making sure that it goes to where you want it to go. And hence we come to binding nominations. So if you want to tell the trustee of your super fund what you want done with your super, you need to make a nomination, okay? Now, on an industry or a retail fund, you'll get your statement, in July or August every year. And on your statement, it'll often say who your beneficiary is if you've made a nomination, all right? So that's all good and well, but the issue is whether it's binding or not. And this is the other thing that the legal industry has been lobbying super funds about, because they don't tell you that a nomination that you make, or they don't make it clear enough whether your nomination is binding or not. And if you do manage to do a binding nomination, the super funds also don't often tell you when it expires, right? Some funds, particularly retail funds, will allow you to do a binding nomination that does not expire. But the standard for industry super funds is that your binding nomination expires every 3 years. So how are you supposed to remember every 3 years to redo your binding nomination? Well, unfortunately, it's a responsibility that you have to wear. So you can do a non-binding nomination. There might be strategic reasons that you do a non-binding one. If you do a non-binding nomination, it is just an indication to your super fund what you want done with your super. It is not binding on them, obviously, so they could end up doing something different. Now, if you did a binding nomination and you allowed it to lapse after 3 years, it becomes a non-binding nomination. So whilst it was binding for the first 3 years, it then lapses, and then the super fund is no longer bound by what you want. And again, they can make their own decision. Now, you can see why it's fairly important for an industry or a retail fund to do a binding nomination, because they don't know anything about you. And you have to at least tell them, you know, who's in your family and who are the important people and what you want done with it. Now, self-managed super funds, it's almost just as important, particularly if there's control issues. So even though while you're alive, you're managing your own super fund, it feels a bit funny to do a binding nomination telling yourself how you want your super fund paid if you die. You still do it anyway for a self-managed fund, because after you pass away, that nomination is still binding on whomever ends up taking control of the super fund. So that essentially helps eliminate any risk in who ends up controlling your super fund, because they are bound by your nomination regardless. So there are all sorts of issues being raised about super funds when there's no binding nomination. So an example would be a husband and wife who have quite a good self-managed fund. They might have 3 kids, say, and the kids, you know, don't get along really well. They're not really close, but there's no open hostilities. But one in particular is quite a controlling sort of person and also has some financial problems. So potentially that child could get control, right? And then if there's no binding nomination, they could pay the whole super to themselves. And there's very, very little recourse for the other children. So that's worst case scenario, but it can happen. And unfortunately, sometimes reality is stranger than fiction. So the circumstances that arise, sometimes you can't predict. So it's better to have control while you can and do a binding nomination to make sure your super goes where you want. So I'm just going to stop the share again for a second and come back in. That worked a bit quicker this time. All right, just scrolling down here. Oh, good. We've had a few more people join us. Oh, good. Kerry, you made it. Hi. And John's there too. Cheryl, how you going? All right, nothing else in the chat for now. Let me go back to sharing the screen. Share. Okay. So who can actually get your superannuation? So there's not much room to move here. So like I said, superannuation is not an asset that's covered by your will. So you have to nominate direct about who you want the super paid to. However, if you nominate someone who's not eligible, your nomination ends up non-binding and the super fund then makes their own decision. So who can you even nominate for it to be binding? So there's 3 main categories. That is a spouse, children, So the children can be under 18 or adults. It's fine. The difference is that children under 18 or potentially students up to 25 don't pay tax when the super comes out, but adult children do. So spouse first, spouse doesn't pay tax. Children is your second category. Third category are financial dependents. So it could be someone who is maybe a grandchild, or maybe a nephew or niece who is disabled that you look after. So they just have to prove financial dependence. So those are your three main categories. So if you have a named person that fits within one of those categories, you can nominate them directly on your binding nomination to get your super. So there's a lot of people who don't have anyone in those categories. And what do? So this is why when people ask me, when should someone do a will? And I reply, well, as soon as they're 18, and if they've been working, they probably have an industry fund, right? So some super has been paid in. Even if it's not much super, as soon as you get an industry fund, you usually have at least 200,000 of life insurance, right? So an 18-year-old or 19-year-old kid, they don't have a spouse, they don't have kids. They're going to sign up to their industry fund, first main job. They're going to put their parents or their brother and their sister or something like that on their nomination form. Unfortunately, not binding. So what do? So actually there is a fourth category. So it's not a person. It is to actually nominate to pay the super into your estate. So you do have to do a nomination to tell the super fund, no, I want the super paid into my estate, and then the will covers it. Hence, your 18 or 19-year-old kid should do their will, get the super paid into their estate, and then do a direction in the will what happens to the super once it's in there. Okay? So, same scenario, kid 18 or 19 who has made a nomination that's not valid and they die in a car accident. So, this child comes from a broken home. He was raised by his mum. He wanted all his super to go to his mum, so that he put her on his nomination form. Passes away in a car accident. Super fund looks at the nomination. Oh, he's nominated his parent. Well, unfortunately, it's not binding. So what happens? The super fund calls for applications. The super fund gets mum to write down who dad is, who stepdad is, who stepmum is, who all his brothers and sisters are. Then the super fund sends out an application form to all them. Some of them might apply, some of them might not. Then the super fund decides. Now, potentially the super fund could decide to pay it equally to the parents. More likely, they're going to pay it into the estate, but this child doesn't have a will. So when someone passes away without a will, their estate goes equally to their parents unless they have a spouse and children. So equally to the parents. This young man hasn't got a relationship with his father. He grew up with his mum. He would not want his father to get anything, but his father ends up with half. So 100,000 plus. So that's the scenario that you could potentially be looking at. Other situations. So a lot of people have someone that they want to leave out of a will. So part of the problem as well is as soon as super is paid into an estate, it's open to claims on a will. So potentially super can be directed to particular beneficiaries and then it can't be disputed if there's a binding nomination. So that's a really handy estate planning strategy. If we're trying to minimize the estate because we think there's going to be a claim, we're going to want to make sure the super has a binding nomination to pay it to someone other than the person we're excluding. And then there's nothing they can do about that. So it's a good way of filtering potentially hundreds of thousands of dollars away and saving it. So you can see that a binding nomination could work both ways. And realistically, it's quite a strategic thing. It needs to be worked through as part of the process doing a will. And also speaking to the financial planner potentially of the person, particularly if there's a self-managed fund. Luckily, with self-managed funds, there's more flexibility on doing nominations. Unfortunately, with industry funds, you can only do what I call a first level nomination. So you can only say what you want to happen and not have a backup. So a lot of husband and wives will obviously have each other on the super. But if they pass away together in an accident, it means there's no nomination at all. So unfortunately, with industry funds, you can't then say, and if my spouse passes away, I want it to go to a particular child or exclude stepchildren or something like that. So again, these things need to be worked through. So I'm going to quickly stop the share. Check a comment here. All right. All right. So converting it from accumulation to pension phase doesn't change it really in terms of a binding nomination, right? So it can change it if you want to pay it to a spouse, because potentially you can just pay or convert the pension to your spouse. But if it goes to anyone other than your spouse, it needs to come out as a lump sum. So that's for industry and retail funds. And potentially self-managed funds, because you can have some of your super in accumulation in your self-managed fund and then some or all of it converted over to pension. So essentially what they do is just an accounting process on a spreadsheet, and they go, okay, so this line item, this account is in accumulation. And when they take it out of accumulation, it just gets another line item and that balance is now in pension instead, right? So it's still in super. It's still affected by a binding nomination. It just gives you a little bit more flexibility in how you deal with it. So you can't pay a pension to adult children. You can only pay a pension to a spouse or minor children. So no, a pension is not covered by your will. It's still the binding nomination. So if you want it to be covered by your will, you have to do the binding nomination saying you want to pay your lump sum into your estate, and then you can direct it through your will. All right, back to share. All right. So we're nearly at the end. I feel like I've been rattling on for a little while. But hopefully you've found it useful. I feel like it might have been a bit dense, full of information. On the screen now, this is my 5-step estate planning process. So my family legacy plan covers this whole process that we've been talking about. So wills, powers of attorney, super nominations, advanced healthcare directives, potentially instructions to guardians, potentially letters of wishes, dealing with gifts, all that sort of stuff. So 5-step process. When you're ready to go ahead with your estate planning, we book an appointment and you get some initial information emailed out to you. First appointment, I do all this strategy stuff with you. I get all the information, I ask all the questions. I talk through scenarios with you and we work out what's going to suit best. Then you go away, I draft everything. If there's any other information I need from you, you get it back to me so I can finalize drafts. If I need to speak to accountants or financial planners, I do it in this period. Second appointment, everything's ready. You come back, you sign everything, everything's valid and done. So it's not a huge commitment from you. It gets done over about a period of 2 weeks. And then after the second appointment, I send in the binding nominations to the super funds. I make sure all your attorneys have signed their acceptances. Any other bits and pieces are all tidied up, and then I deliver the final set of documents to you all certified. So that's how we do it. So tonight, if you're not ready to jump straight into an estate planning process, I do a family situation review, okay? So I do that at a cost of $450. So it's essentially the whole strategy session without the document preparation. So we do the whole review, we work out what you need, whether you need anything at all, then you can think about it. If you decide to go ahead, we roll it into the whole plan. That cost rolls in because we've already done half of the work. But if you don't go ahead any further, the cost is capped there at your first strategy session. So there is a link there on that screen, which I can post into the chat in a second, and I can email to you later if you're interested in going ahead with that. But, quite a few of you already know me and know the guys in the office, so you know how to contact me. And I think that sort of concludes everything. Thank you for coming along. I'm going to stop the share of my slides again, and I'm going to switch back and have a look at questions. So, coming back to you. Here we go. Cheryl, thank you. Am I able to do the process via Zoom and Skype? Yes, most of it. So I can certainly do the strategy session via Zoom and Skype, even by phone. I did it with a lady in Bangkok over the phone the other day. The difficulty is the second appointment. So I can't do that remotely. What I can often do is send the documents out with instructions. The issue is that the law's changed in Victoria over the last couple of years, so there's some pretty strict signing rules for powers of attorney, more so than anything else. So finding appropriate witnesses can be a bit tricky, but I work through that with people in the scenario that there's just no way of us being in the same room at the same time. But Cheryl, you do know that I am all over the place. Melbourne, Wallen, Nagambie, and if I'm heading up your way, I could do Wangaratta if there are 2 or 3 people to see at once. So there's always that possibility. Any other questions, guys? I'm going to stop the recording.